organized by the Litigation and Implementation Unit Center for Human Rights. Today, we'll be discussing the African Court on Human and People's Rights judgment in the matter of Bernard Mornah versus Republic of Benin and 7 others with SAHRAWI Arab Democratic Republic and Republic of Mauritius as interveners. Before we delve into the presentations, I would like to invite Prof. Franz Vihon, Director of the Center for Human Rights, to give the opening remarks.
Thank you very much, Zainab, and good morning, good afternoon. I think we almost certainly delayed the start. My apologies, our apologies for that. Afternoon to those in East Africa, a good evening to whom it may apply. We really thank you for making time, being with us, particularly all the participants who we hope will contribute to the discussion, but particularly the panelists who will give their views on this very important and interesting case. So as was said, we are here in the Center for Human Rights. The class that we use is full of students who are master students on the Human Rights and Democratization in Africa program. We welcome them as well, together with our participants online. As Zainab said, this is the third in a series of case discussions. We started with this last year, and the intention is certainly to make this a constant feature of the African human rights discursive landscape, if you like. We discussed last year 2 cases of the African Court. The one dealt with the death penalty in Tanzania, the Rajabu case, and the other dealt with the reparations judgment of the African Court in the Ogiek case concerning the African Commission versus Kenya. Now, these were 2 cases of the African Court, decisions by the African Court, and today, again, we are looking at a case, a decision by the African Court. So we promise solemnly that in the next editions of this series, we will look at the quasi-judicial bodies, at findings of the African Commission and the Experts Committee on the Rights and Welfare of the Child. So the intention was always to cover all the African human rights bodies, and we will move on to the other bodies subsequently in a few months' time. Now, the discussions are based really on 2 premises. The first premise is that the decisions of the African human rights bodies are important. They are noteworthy. They're important, obviously, to the litigants in particular cases who need outcomes and reparations, but they are also important in terms of building a jurisprudence, standard setting, and clarification of norms that is useful to litigants in subsequent cases, people who study the African Charter and the other human rights instruments, and governments who need to understand their obligations better. The second premise is, despite this noteworthiness, the African human rights bodies and the decisions have received very scant attention. It's been underexplored. And therefore, the intention of this series of case discussions is very much directed at remedying that defect, if you like. We try to, through these case discussions, draw attention, raise awareness, sensitize people about the existence of the African human rights bodies and their decisions, more importantly, perhaps, stimulate critical discussion, reflection, and analysis on these decisions, and also then hopefully ensure that people will understand better and actually use the African human rights bodies to a greater extent. So these are our ambitions. We welcome you. We thank you for your participation and your presence, and we look forward to your also contributions to our efforts to really give greater visibility and greater salience and greater understanding of the African human rights architecture. With these few words, just again, welcome to all. Apologies again for our late start, and I hand back to Zainab. Thank you very much.
Thank you so much, Prof, for the remarks. On that note, I would like to introduce our speakers. And first, we have Mr. Folisho Adegalu, who is the co-manager of the Litigation and Implementation Unit. Next, we have Mr. Ahmed Sidi Ali, the representative of the SAHRAWI Arab Democratic Republic. We have Dr. Zelalem Tefera, who is a senior legal officer in the African Court on Human and People's Rights. We have Advocate Praise God Milen Joseph, who is the program officer under the Human and People's Rights Program at the Pan-African Lawyers Union. And finally, we have Mr. Ikechukwu Uzoma, is the Africa Staff Attorney at the Robert F. Kennedy Human Rights, a Washington-based human rights organization that has worked to advance human rights across the world. So we'd like to call on Mr. Folisho to give us an overview on the case we'll be discussing today.
Thank you very much, Zainab, and welcome once again to everyone, both online and our physical audience in the class. And let me join Prof. once again to really apologize for some of the mix-up that have led to this program starting a little bit behind schedule. So what I just want to quickly do is, because this year is quite a very lengthy one, it's about 100 pages, and I just think it's also important for us to just have a broader picture of some of the critical issues that our subsequent panelists would be talking about. So let's start with the parties before the court. So it's a very long list. You'll see a lot of respondent states. There's also the interveners and all of that. So why do we have all of these? The applicant in this case is a Ghanaian national. His name is Bernard Moya, and he's the chairman of the Convention People's Party, and is the one that has brought this application, the real sense, before the court. So the respondent states, they are the, as at that time, the states that have made the African court, that have ratified the African Court Protocol, and most particularly that have made the Article 34.6 declaration, because remember, Mr. Bernard is an individual, and for the states that you can sue as an individual under the court protocol has to be the states that have ratified the court protocol and that have particularly made the Article 34.6 declaration. So that's why you have all of those respondent states in the which are Republic of Benin, Burkina Faso, Cote d'Ivoire, Ghana, Mali, Malawi, Tanzania, and Tunisia. So one thing to quickly flag here is that, of course, subsequently after the case was filed, Tanzania, Benin, and Cote d'Ivoire withdrew the Article 34.6 declaration, but the court ruled that the withdrawal of Article 34.6 declaration by state does not affect, cases that have been filed before the withdrawal. So that's why we have all of those 8 states. Now, there's the interesting part again is that we now have interveners. So why do we have interveners? I mean, normally we would have our applicant, we would have our respondents. So the reason we can actually see that in the subject matter of the application before the court. So the subject matter of the application before the court by Mr. Bernard is that Mr. Bernard is alleging human rights violation of the Sahrawi Republic people due to the erosion of sovereignty, territorial integrity, and independence of Western Sahara because of the continued occupation of Morocco. So now, because this judgment eventually, we border on things that has to do with Sahrawi Republic, the Sahrawi Arab Democratic Republic applied to the court as intervener. And also because of historical ties, which I will not go too much into, because Mr. Sidali, who is from the Sahrawi Democratic Republic, will provide us some of this contextual information. Mauritius also applied to the court to be an intervener in this case. So that's why we have the applicant, Mr. Bernard, and we have the respondent states in the 8 states that have made the Article 34.6 declaration. And we also have the interveners, the Sahrawi Democratic Republic and Mauritius. And because of the interesting nature of the case, which we would all see as we go along in the discussion, the court on its own invited a couple of NGOs to submit amicus briefs on this case. And based on that, PALU, Pan-African Lawyer Union, which as Zainab said, one of their program officers will be talking to us, filed amicus before the court, and they also participated, the organization participated in public hearing and oral session before the court. So we would have people from Sahrawi Democratic Republic, Mr. Sidali, talk to us from the perspective of the intervener. We would also have someone from PALU to also talk to us from their perspective as an amicus in this case. So like I said, the allegation, the alleged violation is that Morocco continued occupation of Western Sahara is a violation of the rights of the people of Sahrawi Republic, sorry. But then specifically now, the ground of the allegation is that Morocco's admission. So the African Union admitted Morocco back into the AU, and the applicant is claiming that the admission of Morocco to the AU is inconsistent with the objectives and principles of the African Union as stated in the Constitutive Act and other relevant instruments. And the applicants allege that the respondent states now should be held responsible for their failure, both individually and collectively, to defend the sovereignty and territorial integrity of and independence of Sahrawi Democratic Republic, because they failed to, oppose to the admission of Morocco into the AU. So the applicants' prayer was very simple, that the court should order the respondent states to call an emergency session of the Assembly of the AU, because the respondent states, of course, are member states of the AU, and that they should sponsor a resolution to restrain Morocco from further occupying part of Western Sahara Republic. So it was a very contentious case. There was a lot of objections on jurisdiction and admissibility, which Dr. Zilalem, the senior legal officer from the African Court, will be talking to us about in detail. But eventually the court did rule that it has jurisdiction to entertain the matter, and it admitted the case was admissible. But the general finding of the court, which again I would not go, which I would not also go too much into the detail, is that after deciding that it has jurisdiction, it has the case is admissible. The court, however, found that there is no violation of the right to self-determination of Sahrawi Democratic Republic, and dismissed the request of the applicant for an emergency session of the Assembly of the AU and the resolution restraining Morocco from further occupying parts of Western Sahara. So I think that's just the general background story to this case, and I would hand over to Zainab.
Thank you so much, Mr. Folusho, for the overview on the case. And to not waste any more time that we don't have, I would like to call on Mr. Ahmed, representative of the Sahrawi Democratic Republic, to give us his presentation.
Assalamu alaikum. Good morning, everyone. Good morning, good afternoon, Prof. William, and the alumni students, distinguished panelists and guests to this webinar. Let me start by thanking the Center for Human Rights of the University of Pretoria for the kind invitation, and also I'm very honored and delighted as a former this very interesting webinar. I'm speaking in this webinar in my personal capacity and not on behalf of the government officially. So I'm interested really to have changing views with you in my personal capacity. The ruling of the courts is overall a total victory of the Sahrawi people with the magnitude of the 2004 advisory opinion of ICG on the Palestine or the 2019 opinion on the Chagos. The ruling of the court's unique and fascinating on many instances. Indeed, it was the first time that the court was asked to rule on the right of self-determination and independence of the people of the state party to the African Charter. As the court is a judicial outcome of the collective struggle of African people, the court is rooted in the decolonization of Africa. This case tells a lot about the institutional achievement of Africa as a continent. It's also reminds us that some of the African people still suffer from the foreign occupations and unfinished decolonization as such as Western Sahara and Mauritius in between Chagos. It is the first time that an international court recognized explicitly the right to self-determination as a due conis norms. Only the erga omnes characters in the case law of ICG. Very solemn moment for the Sahrawi people, because it was the first time that CDR would appear a state before International Court. On the procedural issue, and also I want to share with you some few ideas about the admissibilities and the interest of the applicants. The ruling reflects the unique nature of the African human rights system component to the, if you compare it to the European, the inter-American, and even the UN human rights system, since it's allowed for actio popularis by African citizens. The ruling is vibrant testimony that the enforcement of human rights at the African level is a matter of collective struggle due to the past history of Africa. The case law of the court is also consistent with the existing case law of the African Commission on Human and People's Rights, which also accept the actio popularis and confirmed on many occasions that the applicants do not have to be victims of the alleged violations for their applications to be admissible. So this is also very important. I also want to share with you a few remarks in terms of the jurisdiction of the courts. On the issue of jurisdiction, the court was facing unsolved question in the case law. I will address some of them. Firstly, whereas the notion of jurisdiction with the meaning of the international human rights law is mostly territorial, the courts agreed with the CDR submission that this only concern individual rights, but not collective rights such as the rights of self-determination. In this regard, I must underline that the African court was in an unique positions. For instance, if Article 1 common of the 1966 International Conference protect the right of self-determination is limited to individual rights, beside the European and the inter-American courts have no jurisdiction over the collective rights. As regards the ICJ, the courts ruled several times on the issue of self-determination, but only in the frame of advisory opinions. Therefore, the ruling of the African court is the first instance worldwide of the contentious case dealing with the question of the relation between the notion of the territorial jurisdiction and the right of self-determination. In this regard, the court confirmed the obligation to respect and enhance the right of self-determination is not territorial bound, but also apply to the situations located outside of the territory of state parties. This solution is fully constituted with the erga omnes character of the right to self-determination. My second remark relates to the indispensable third-party principle. Despite that Morocco not being a part of the proceeding, the court finds that it has jurisdiction towards the defendant status because Morocco's unlawful occupation of Western Sahara is a given based on UN and AU resolutions. By comparison, in the East Timor case of '95, the ICJ ruled that it could not decide on the Australia liability without prior assessment on the legality of Indonesia behaviors, which did not constitute the jurisdiction of the World Court. In this regard, the ruling of the African Court confirmed that an advisory opinion from the ICJ entails an authoritative statements of the international law on the question with which it deals. As recalled by the International Tribunal for the Law of the Sea in its judgment on the preliminary objections in the dispute concerning delimitation of the maritime boundaries between Mauritius and Maldives in the Indian Ocean in 28 January 2021, paragraph 202. Indeed, in 1975, the ICJ ruled that there never existed any ties, territorial sovereignty between Morocco and Western Sahara prior to the Spanish colonization to the territory. Given the serious unlawfulness of the Morocco invasions under international law, a war of aggressions waged against the Sahrawi people with a genocidal component, Western Sahara was always independent from Morocco, will never be part of the Morocco territory. To the contrary, as ruled by the African Court, and I quote, the sovereignty of the people of CDR over Western Sahara is a settled fact. Hence, it is clear that despite of prolonged nature of Morocco's occupations of Western Sahara has no future, and Morocco never gained and never will gain any inch of sovereignty over Western Sahara. The court sent a powerful message to the international and African community that crime will never pay off. On the exhaustion of the local remedies, also I want to share a few ideas if the time will allow me. We were satisfied actually for the courts that follow the line of the arguments we made in this matter. Also the finding of the courts on the exhaustion of local remedies that massive violations of human rights were committed in Western Sahara is fully consistent with its finding on the merits of the case of Morocco's prolonged occupations of Western Sahara is illegal and contravenes with the right of self-determination. So I want to, if I still have the time, I will also share with you a few remarks in terms of substantive aspects of the ruling courts. It's developed on the duty of non-recognition and the non-assistance in terms of the positive and negative obligations with links to the case of the ICJ on Namibia, Palestine, and Chagos, and also with the ILC 2009 draft articles on the state responsibilities. And I mention here, basically, the ruling of the African Court is a concrete applications of the ILC draft articles and of the case law of the ICJ. The ruling of the African Court is the equivalent for the Sahrawi people of the 79, 2004, and 2019 advisory opinions of Namibia, Palestine, and Mauritius peoples. The ruling of the African courts bear the same strength on the core issue of international law. The implications of the court decisions, as we see, the ruling of the African Court is instrumental and decisive in the border of struggle of the Sahrawi people to achieve self-determination by legal means. In particular, the ruling of the African Court, echoes, complete, and reinforce the case of law of the European Court of Justice. Firstly, in 2016, the European Court of Justice ruled that Western Sahara has a separate and distinct status from Morocco, according to the principles of self-determination. In 2000, the same court also ruled that taking account, and I quote here, taking account. Hello? Hello? Hello?
You have 1 minute left.
Can you hear me? Hello?
Sir, you have 1 minute. Thank you.
Hello? Hello?
Yes, we can hear you.
Hello? Hello, can you hear me?
Hello, can you hear me?
Yes, I hear you. Can you hear me?
1 minute. Thank you.
Hello? 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 Hello?
Okay, thank you so much, Mr. Ahmed, for your presentation. I would like to call on the next speaker, Dr. Zelalem. Dr. Zelalem, you have 20 minutes for your presentation. When it's 5 minutes left, I will put on my video or send you a text. So kindly check your chat box. You have 20 minutes for your presentation, Dr. Zelalem. Please start your presentation. Thank you.
Thank you. Can I share my PowerPoint? Can you hear me?
Yes, it has been enabled for you to share your PowerPoint.
All right. Well, I can't share. Let me speak from my PowerPoint. Unfortunately, I cannot share. First and foremost, thank you very much for inviting us to be part of this important event. We don't take it for granted. We are honored, and we understand how much value the center gives to the jurisprudence of the court. And we appreciate its role in creating awareness on the work of the court. So coming back to this judgment, this is one of the most important landmark judgments of the court. And as the previous speakers pointed out, this is an important judgment for the fact that it affects not just the parties in the case, but the entire continent. The case was, as a background, the case was filed against 8 states, 8 African Union member states, and maybe in case some people ask why the applicant chose to file against only 8 out of 55 countries, it is simply because these are the only countries which at the time allowed individual access to the court. So that's why the applicant was constrained to file this application only with respect to the 8 countries. I would like to point out that Morocco wasn't a party to this case because Morocco hasn't ratified the charter, the protocol, and deposited the declaration under Article 34.6 of the protocol. And even if it was invited to appear, the Morocco didn't appear or requested for intervention. Benin, at the initial stage of the proceeding, Benin participated, but at the end it defaulted. So the judgment was rendered against Benin in default. Just an additional background, according to the applicants, Western Sahara was colonized by Spain until 1976. And after Spain's departure, Morocco and Mauritania occupied Western Sahara. And in 1984, as you know, the Sahrawi Arab Democratic Republic was admitted as a member of the former Organization for African Unity, and in protest, Morocco left the organization. And on 23rd September 2016, Morocco officially submitted its application for admission to the African Union. The African Union is, you know, the OAU is a predecessor of the African Union. So later on, the Kingdom of Morocco filed for admission to the new organization. And on 31st of January 2017, we know that the Kingdom of Morocco was admitted to the African Union. And the application was filed before this court, before the African court, against this background of Morocco's admission to the African Union. The application was filed at the court, at the registry of the court, on 14th of November 2018 by Bernard Mornah, who is a Ghanaian national. Since the alleged violations were pointed out by Fulusha, I wouldn't go into details, but I would like to point out that the applicant alleged violations of several rights based on three instruments, three treaties. One is the Constitutive Act of the African Union. The second one is the African Charter on Democracy, Election, and Governance. And the third one is the Charter, the African Charter on Human and People's Rights. The court, of course, as it is customary for the court, it started to deal with its jurisdiction as the first step to deal with the application. And in the jurisdiction sections, the respondent states raised several objections relating to the court's material jurisdiction, personal jurisdiction, temporal jurisdiction, and territorial jurisdiction. And I will go and discuss those objections, starting with material jurisdiction. With respect to the court's material jurisdiction, the court identified and addressed 4 objections which were raised by the respondent states. The first objection that the court dealt with was the respondent states allegation or objection that the application raised political and diplomatic nature, or the application has had issues which somehow touch on political and diplomatic issues, and conflict with the principles of state sovereignty and non-intervention. This was the first objection raised by the respondent states, and the court responded that an application may raise issues of a political or diplomatic nature, or even may seek reliefs that may require political decisions or diplomatic solutions. However, the court underlined that, however, as long as an application contains allegation of human rights violation, the court has the competence to consider and examine that allegation. So the court rejected the respondent states objections that since the application raised issues of political and diplomatic nature, the court shouldn't have jurisdiction or competence over this application. So the court rejected that argument. And regarding the issue of sovereignty, that's some of the respondent states raised as an objection, the court reaffirmed that indeed international law is a consensual undertaking. But once states agree to the jurisdiction of an international tribunal like this court, they cannot raise the issue of sovereignty or non-intervention. So again, the court dismissed this line of argument or objection of the respondent states. The second objection I raised against the court's material jurisdiction was that the application was based mainly or only on the Constitutive Act of the African Union and the admission of Morocco to the African Union. This was the second objection that they raised. Again, the court rejected this objection, and by saying that the application was not exclusively based on the African Union's decision to admit Morocco to the African Union, but also the alleged general behavior or attitude of the respondent states towards the suffering of the Sahrawi people. Furthermore, the court noted that the application, apart from reference to the provisions of the Constitutive Act, also contains allegations of violations of the Charter and other human rights instruments ratified by the respondent states, which, according to Article 3 of the protocol, are within the competence of the court. Sorry, the third objection to the material jurisdiction of the court raised by the respondent status is that the application is a request for an advisory opinion and dealt with a dispute over ownership of a territory. If you look at the application submitted by the applicant mentioned Article 4 of the protocol. Article 4 of the protocol deals with the power of the court to issue an advisory opinion. And some of the respondents said that since the applicant cited Article 4, which deals with the issue of advisory opinion, this application should not be treated as a contentious application, but it should be seen as a request for advisory opinion. And the court said, no, even if the applicant cited Article 4, this doesn't mean that this application should be treated as a request for advisory opinion. In fact, the applicant seemed from his application, the applicant seems to be very clear about his position that he intended to request to file a contentious application, not a request for an advisory opinion. And interestingly, the court also responded to the respondent's submission that this application deals with issue of ownership over a territory, and the court doesn't have jurisdiction to address issues of ownership over a territory between two or more sovereign nations. The court underscored that the determination of whether some rights are being violated by a state doesn't necessarily require it to delve into the issue of ownership of a territory. It acknowledged that it doesn't have jurisdiction to determine ownership, but it pointed out that the fact that an application relates to the ownership of a territory doesn't mean that the court is divested of the power to deal with human rights issues relating to the ownership of a particular territory. So it is a very interesting position that the court took, because some of the respondent states were trying to make sure that the court doesn't entertain this application by alleging that this is an issue relating to ownership of a territory between two member states of the African Union. The fourth objection to the material jurisdiction of the court was that the AU Assembly has transferred the matter to the United Nations. So some of the respondent states noted that during the Nouakchott summit, the African Union decided to transfer the issue of the referendum and the issue of the Sahrawi Arab Democratic Republic to the United Nations. But the court made reference to the relevant AU Assembly's decision and found that the African Union, in fact, did not disengage itself, but rather reaffirmed its commitment to a permanent political solution to the problem. The court also made a distinction between the political process within the African Union and the judicial proceedings initiated by the applicant, and it held that the political process within the African Union and the United Nations does not oust the competence of the court. So accordingly, the court dismissed all the four objections to its material jurisdiction and declared that it had material jurisdiction to entertain the application. And then the court proceeded to the personal jurisdiction. As you know, the personal jurisdiction of the court is governed by Article 5 and Article 34(6) of the protocol. And even if some of the respondent states challenge its applicant's locus standi, claiming that he was a Ghanaian national with no direct or relevant link with the people of Western Sahara, nor was he a victim of the alleged violations. The court says that by recalling its jurisprudence, established jurisprudence, it said that the protocol does not require individuals or civil societies or NGOs to demonstrate a personal interest in an application in order to access the court, especially in the case of public interest litigation. So the court rejected the respondent state's objection in this regard and held that it has personal jurisdiction. So it's a reaffirmation of its jurisprudence that for purpose of personal jurisdiction, the applicant doesn't need to be a direct victim. He can access the court as long as the respondent states have ratified the protocol and deposited the declaration with respect to a particular situation. Then the court proceeded again to examine its temporal jurisdiction. Even with respect to its temporal jurisdiction, some respondent states had raised objections, but the court concluded that it had temporal jurisdiction because one, the respondent states except Tunisia became a party to the charter and the protocol, and deposited the declaration under Article 34(6) prior to the date when Morocco officially filed its request to join the African Union, that is on 22nd September 2016. And second, even with respect to Tunisia, the court says that it has temporal jurisdiction because the nature of the violations alleged to have been committed by the applicant is continuing. So as long as it's a continuing violation, the issue of temporal jurisdiction should not be treated the way it is with respect to other instantaneous violations. So the court concluded that it had temporal jurisdiction to entertain the application. Finally, and Mr. Ali pointed out, rightly so, that with respect to its territorial jurisdiction, the court somehow came up with this very innovative approach to deal with its territorial jurisdiction. It was for the first time in its history that the court accepted the extraterritorial application of its jurisdiction, or the extraterritorial scope of its jurisdiction by making reference to the nature of the right to self-determination. The court noted that the right to self-determination is a right with no geographical scope. So the obligation arising from the right to self-determination extends beyond the normal traditional boundaries of member states of the African Union. And as a result, the court said it has jurisdiction, a territorial jurisdiction.
You have 5 more minutes, Doctor.
Okay.
Thank you.
It has a territorial jurisdiction with respect to this application because of the nature of the right to self-determination. And I would say this is a very innovative way of interpreting its jurisdiction. And with respect to, if you look at the judgment, it has a section on jurisdiction and second admissibility. Third, it has merits section, and the final one is the reparations. In addition to the operative part. But just to speak on the second part, that is admissibility, the respondent states raised several objections relating to the requirements that are specified under Article 50 two of the rules of the court, or Article 56 of the charter. And the court rejected all objections to the admissibility of the application and declared that the application is admissible. Unfortunately, I'm not going to go in the interest of time. I'm not going to deal with each and every requirement, but I'll share with you the presentation later. So please allow me to go directly to the merits, because the merits section has some important points which I think deserve some fair treatment. So in the merits section, the court first made some preliminary remarks. The first one is that the court pointed out that even if the applicant raised several claimed violations of several rights, the court decided to limit itself to the right to self-determination. It is very interesting because despite the fact that the applicant, for example, raised violation of the right to development, the right to peace, right to satisfactory environment, so and so on, the court said that at the core of his application lies the claim that the people of Western Sahara, Sahrawi, have been affected because of the continued occupation of Morocco, and this is essentially an issue of the right to self-determination. So the assumption of the court is that as long as you deal with the right to self-determination, you also automatically deal with the other rights which were alleged to have been violated. But the court also was very careful in pointing out that the other rights which were alleged to have been violated were autonomous by their nature. So it is interpretation of this situation is very case specific. I would say it is case specific. So we cannot extend this approach to other situations. It limited itself by saying that in the current context, the specific circumstances of the case, the respect of the right to self-determination means that it is also the respect, ensures the respect for the other rights which were claimed to be violated by the applicant. So that's the first preliminary remark that the court made. The second one that the court pointed out was that with respect to the respondent states in this case, it wasn't an issue of annexation. So even if it is related to the right to self-determination, it's not that there is the current respondent status, the instant respondent status were alleged to have invaded the territory of Western Sahara or the people of Western Sahara. So the court noted that their responsibility doesn't relate to direct conquer or occupation by the respondent status. Instead, it is related to the issue of admission of Morocco to the African Union. The second important aspect of the judgment or the merits section was that the court considered the historical realities of Africa, and it tried to define the right to self-determination based on that historical reality. And the court, very interestingly, the court said that the nature of the right of self-determination must be understood in the light of its unique place and its relevance to the African continent and to the African society. And then it mentioned the history of colonization, the history of foreign oppression and domination in the continent. And it underlined that the history of the African continent was defined by a history of colonization, which defines the African identity itself. And history as inherently and inextricably intertwined with the struggle for self-determination. I would say that it was so important that the court informed its definition and understanding towards the right to self-determination based on the historical realities of the continent. I would say this was a very interesting part of the merits judgment. And the third part in the merits, which was in the merits section, which was very interesting, is that the court again affirmed that the right to self-determination is an element. It's an element of the right to existence of peoples. So the court related, based on Article 20 of the Charter, it related the right to self-determination with the right to existence of people. So that is also a very important point, relevance in understanding the right to self-determination in the future and across the continent. If I have time, may I continue?
Yes, you can.
Okay. And the fourth interesting aspect of the judgment is that the court reaffirmed the extraterritorial application of the right to self-determination. As I mentioned earlier, in dealing with its territorial jurisdiction, the court said that the right to self-determination is owed by a state to say to self. Hello, can you hear me?
Yes, we can.
Hello? Hello?
Yes, we can hear you now.
We can hear you.
Sorry, I got interrupted.
That's fine.
Okay. The fifth interesting aspect of the judgment was that the court again affirmed the inextricable relationship between the right to ownership over a particular land and the right to self-determination. So you would recall that in the jurisdiction sections, the court said it doesn't have the competence to deal with ownership over a particular territory. The court acknowledged that the right to self-determination cannot be exercised unless, or cannot be materialized unless there is a territory that people could consider as their homeland. So this is also another contribution, jurisprudential contribution of the court's judgment. Then the court dealt with the responsibility of the respondent states. So it dealt with the issue of the obligation to give assistance. And the court, by recalling the international law of responsibility, it says that three conditions must be fulfilled in order to hold a particular state responsible for an international wrongful act. Such as there must be an international wrongful act, the act must be attributed to the respondent status, and there must be a causal link between the act and the wrongful act and the conduct of the harm which was caused by that act. So after discussing these standards, the court applied it to this particular application case, and said that when it comes to the responsibility of the instant respondent status, Article 20 of the Charter talks about the obligation to give assistance. In fact, if you look at Article 20, it doesn't talk about the obligation, but it says peoples have the right to get assistance. So the court interpreted that right as giving rise to an obligation on the member states or the state parties. So that obligation, according to the court, is something which gives the state parties to decide on the nature of assistance that they would like to give to the people. And based on this understanding and interpretation of that obligation to give assistance, the court decided that the instant respondent status didn't violate Article 20 of the Charter. And the court gave about 4 reasons why it declared that there was no violation. The first one, is, as I said, is I have a minute.
Yes, to wrap up.
Okay. Just to say that the court did not find violation, and it provided about 4 reasons as to why it didn't find violations. I think everything relates to the way the court understood the concept of the obligation to give an assistance to peoples under colonial domination. But just as a final remark, the court, after it declared that there was no violation, it also went ahead and wrote what we call in legal dictionary vocabulary, what we call obiter dictum. So having held that the respondents did not violate the rights of the Sahrawi people, the court reiterated that the respondent status, and indeed, not only the respondent status, indeed all state parties to the Charter and the protocol, as well as all member states of the African Union, have the responsibility under international law to find a permanent solution to the and to ensure the enjoyment of the right to self-determination of the Sahrawi people, and not to do anything that would give recognition to such occupation as lawful or impede their enjoyment of this right. So this is a very important part of the judgment. It recognized the jus cogens nature of the right to self-determination and the erga omnes nature of the obligation, which arises from the jus cogens nature of the right to self-determination. I think that the fact that there was no violation didn't mean that the respondent status, according to the court, do not have any obligation, or their obligation ceases to exist. Rather, the court affirmed that their obligation to assist the people of Sahrawi is an outstanding obligation and a continuing obligation. So I would say that this is a very important and courageous steps that the court took in order to reaffirm that the people of Sahrawi need to have the right to decide on their future and their fate. I'm sorry for taking time, but this is a very, I would say, very voluminous judgment, and I hope you got some important elements of the judgment. Thank you for giving me the opportunity.
Thank you so much, Dr. Zelalem. Thank you for your talk. To not waste much time, first to announce, we would make his slides available after the discussion, so we apologize for not being able to share slides. And on that note, I would like to call on Advocate Praise God to give a presentation. You have 12 minutes to give your presentation. Thank you so much.
Thank you so much, Zainab, and thank you so much for the institution to give PALU this opportunity. As PALU being a continental forum, we have worked closely with the African Court and other regional courts in ensuring that to promote access to justice, democracy, and good governance in Africa as a continent. And through our activities, PALU was given the privilege by the African Court to take part in this case as amicus curiae of the court. And we were able to file our submissions, but also attend for oral hearing of the case. And as the previous speakers have well explained on the brief circumstance of the case, but also on the summary of the judgment, specifically touching on different issues that the court had considered, I will give a brief highlight on other areas and adding on to what the previous speakers have spoken. And in line to one of the issues that as PALU have taken through this judgment in what it has provided for is on issues of admissibility, especially on the area of exhaustion of local remedies. As through our experience, we have had that most of the respondent state usually raises an objection on different cases that are filed on the ground of lack of exhaustion of local remedies. And the same was raised also in this case, and whereby the court provided a clear understanding on what exhaustion of local remedies and the exception to it are covered within the charter. So the court proclaimed itself and decided that though the respondent raised that the applicant Bernard had different options of going for exhaustion of local remedies, as other states had initiated that in their local courts had the availability of the possibility to file the case on issues of international instruments, and the case would have been had at domestic level. But the court went further and said that such a situation, and looking back into this current case, that it had 8 respondents in it where it had to be determined, and it was either for the applicant to file different cases in all the 8 countries, but also because the fact that if the applicant would have filed one case at one specific country, say Ghana, where he came from, that would also limit the Ghanaian court to give decisions upon other countries that are not party to their local laws. So the courts looked at that situation and looked at how the prolonged and non-existing of also other courts' ability to determine cases that were not of their own doing. That means reflecting to other countries' laws, but also other countries' obligation. So that's one of the areas that the court in this particular case expounded on what exhaustion of local remedies really require. But also when looking at this case, the court also stated on issues of relying on media, because among the objections that were raised by the respondent states was the fact that the applicant had relied on some evidence on media, especially looking into the fact that the applicant himself does not reside in any of the 2 countries, especially does not reside to West Sahara, where he claims of the violations have been overtaken. So with this, the court spoke into it and declared that though some of the information have been based on media, but not all information are based on media. It's not exclusively on media. Also, the applicant had relied upon different resolution, both of the African Union, but also of the UN, whereby they clearly provided of the situation that is currently occurring to the Saharian people. So such a situation, we see that the court has clearly expounded on what amounts to relying on media, exclusively on media information when filing a case at the African court. It also expounded on areas whereby such information are reliable and can be found anywhere, because the court clearly stated that the reason why media information are not based on is the fact that how reliable are information posted on the media. But in this situation, the court went further and explained that it's not only through the media, but there are also other reports from both AU and the UN that have expounded on the situation that is occurring in that area. And also the issues of on issues of reasonable time, the court has explained itself in this case on the issue that being a human rights violation, there's a concept of the continuous violation, as also explained by the previous colleagues, that when filing a case at the African court and other human rights courts, the issue of continuous violation, we don't look just when the violation occurred, but we look at how continuous the violation is. Be it as the situation of this case, the situation of Morocco occupying the Western Sahara has been from time, but then such violations are continuous. So when the applicant filed the case, had justifiability according to the admissibility requirements that file the case on reasonable time since the violation are continuous. And as said by my colleague, the issues in such as a case that they really raised an objection of how the applicant was able to file the case. There's issue of the public interest that comes along on issues of human rights, that one person should not show that they are specifically harmed or have specifically suffered on that violation, but they can file it on issues of public interest for the better of all the public as the particular case. And looking at something else this case has brought in light, and as my previous colleagues have also said, is on how the judgment has come and spoken about the issues of right to self-determination. And it has not only limited the issue of self-determination as self-determination, but it has gone broad to expound that the right to self-determination covers a multitude of other rights. As you'll see, the applicant had provided right to self-determination as one right of violation and had also mentioned other different rights that have been violated. But the court went on and explained that it will stick on the issues of right to self-determination because the right to self-determination gives the right to existence of the people of West Sahara. So the issue of right to self-determination, if it's decided upon, it's determined upon, it will cover the other rights that had also been mentioned by the applicants. And it will also determine if there was violation of all rights and other freedoms that were recognized, as also explained by the previous speaker. But also in this judgment, we see how the court has spoken about the issue of individual obligation of the state, but also a collective obligation of the state, where it has clearly stated on how state as individual had an obligation or could go further into ensuring that the right to determination of the people of Western Sahara is upheld, or could have done it jointly to ensure that the rights of the people of the Western Sahara are protected. And this is whereby, as Zelan has said, that though the judgment at the end, it is clear that the court had decided that the respondent state specifically had not undertaken violation of the human rights, but it has expanded itself and stated that though that violation has not been done, but the respondent states and has recognized the right to self-determination of the people of Western.
3 more minutes.
Pardon?
3 more minutes.
Oh, okay. So among the things that this particular judgment has done, and the precedent it has set to the African continent, is that one can first adjudicate on issues of right to self-determination. And it has given a broader understanding of right to self-determination is not only limited to one particular state that is violating the specific right, be it here the country of Morocco, but it has given it a wider understanding that it also gives an obligation to other countries to ensure that though one particular country is violating the right to self-determination, it has also set an obligation to other countries to ensure that they take initiatives, they take steps to ensure that the people of that particular country, in particular in this case, the people of Western Sahara, right to self-determination is upheld and is recognized by Morocco as a state, but also as Africa in general. So with this, we have taken an initiative of the issue that was spoken by Zelan and the other speaker, that there's an issue of extraterritorial obligation or extraterritorial effect. Though the 8 states personally did not undertake any initiative to ensure that Morocco takes over the territory of Western Sahara, but they had an obligation as a state to ensure that the right to self-determination of that particular country is upheld. So they were required individually as a state, but jointly as a community or as a union of African Union to ensure to take steps so that the people of Western Sahara right to self-determination is achieved. So we can see that the jurisprudence of the court is developing as time, and we can see now how as a continent we can push towards this particular judgment as it stands towards implementation of different sectors of the judgment that have been decided by court, and to ensure that states particularly implement Like now the judgment has provided that there is issue of right to self-determination. And since the judgment has been decided, what initiatives as a state or as individual people have we taken to ensure that implementation of this judgment? What have we done to the existing African Union states to ensure that in the coming sessions of the African Union states, how are they going to push towards implementation of the decision through this judgment, especially on issues of right to self-determination of the people of West Sahara? That I'll stop there, Zainab. Thank you.
Right. Was on your time was up, so the last speaker also understands that. So kindly type your questions in the chat box. Announcements, and last but not the least, I would like to call on Mr. Ikechukwu to give his presentation. You have 12 minutes.
Yeah, apologies. I think issues with the connection again. But let me thank everyone who's spoken. Thank you so much for your thoughts, and thanks to the Center for organizing this. Since everyone has so eloquently spoken about, the admissibility section of the decision, the jurisdiction, all of that, I do agree with the points that have been made by everyone regarding how groundbreaking and how, in a sense, even courageous the decision of the build up to the decision of the African court was in terms of these preliminary issues. However, I feel the bulk of my presentation today would be a critique of the decision, especially on the merits part of the decision. Now, the courts in the Mornah decision identified that the self-determination issue, and in particular Article 20, was the crux of the matter. So basically, the courts decided to limit its determination to the self-determination question, and in particular, whether or not in the language of the court, whether or not the respondent states, the 8 states, had committed any wrongful act for which they should bear responsibility. Articulating those issues in paragraph 285 of the decision, the court said that the present application is essentially and firmly linked to the right to self-determination, particularly the right of the Sahrawi people to obtain assistance in their struggle for freedom from foreign domination, unquote. The court went forward to talk about the positive and negative obligations. However, in paragraph 303 of the decision, the court deviated, I would say, from the crux of the case when it characterized the question before it as whether the respondent states should be held responsible for Morocco's violation of the Sahrawi's right to self-determination. Initially, the characterization was whether or not the respondent states had an obligation because, or had a responsibility because they didn't fulfill their obligation under Article 20. But in 303, the court now said that the question was whether the respondent states should be held responsible for Morocco's violation of the Sahrawi's right to self-determination. Now, why is this problematic? It's problematic because there seems to be, to my mind, a graduation from or an application of the same threshold that the court had for Morocco's violation of this right to self-determination of Western Sahara. There seems to be an extension of the same threshold to the determination on whether or not the respondent states fulfilled their obligation to Western Sahara based on the provision of Article 20 and international law broadly. In my opinion, the court, I think, hamstrung itself by attempting to determine whether any wrongful act could be imputed to the respondent states and whether there was a causal link between such wrongful act and the violation of the right to self-determination of the Sahrawi people. Now, as far as the court had said, the issue for determination was whether or not the 8 states fulfilled their obligation to A, support the efforts of Western Sahara towards self-determination, and B, refrain from doing anything that will militate against the efforts of Western Sahara to attain self-determination. Recharacterizing that as whether or not the states would have responsibility for Morocco's occupation of Western Sahara was a different question altogether. And I think that's where things got mixed up. And that may have been the reason we ended up with a decision that pretty much said that there was no violation of the rights of the Sahrawi people based on the action or inaction of the 8 states. Now, let's take that further. Particularly in paragraph 313 and 314, the courts acknowledge the context of the issue or of the case and of the situation in Western Sahara, and went even further to say that when Morocco requested their readmission into the African Union, knowing that Morocco left the African Union because Western Sahara had been admitted, that the respondent states, in the words of the court, could have taken certain steps to galvanize support from other state parties to object to Morocco's admission or to make the admission, Morocco's readmission, conditional on the self-determination of Western Sahara. In paragraph 314, the court, and I would say respectively, erroneously asserted that the absence of evidence before it showing that the states did or failed to take certain steps to object to Morocco's admission or make the admission conditional on the respect of the rights of the Sahrawi people was the reason why they couldn't hold that there was a violation. That means there was no evidence before them to show that the states did not or did something to support the rights of the Sahrawi people. But the court went further to say that even if that evidence existed, it would not by itself amount to a violation of international obligations arising from the African Charter. Because, and this is important, the court said because Article 20 of the Charter which imposes the obligation did not require the states to take a list of specific actions or measures of a particular notion. Therefore, it is up to the respondent states to decide what kind of positive measures they would consider appropriate for the realization of the rights of the said people. To my mind, the phrasing of the court, first of all, on the absence of evidence, seemed to place the burden of proof for the fulfillment of an erga omnes obligation. Let's remember that the issue here is this is a preemptory norm of international law. It's customary international law for which there cannot be a derogation. What the court said, to my understanding, is that the burden of proof was on the applicant to show that the states did or did not fulfill their obligation. And I think that was wrong. The burden of proof should have been on the states to show whether or not, in understanding that obligation, whether or not they fulfill that obligation. Secondly, the phrasing of the court that the states could have galvanized efforts and from other states to support Western Sahara seemed to belittle the seriousness of the issue. Self-determination is equivalent in international law speak to other preemptory norms of international law, including the prohibition against genocide, the prohibition against slavery, the prohibition against crimes against humanity. So for the court to say that the states could have, and to make it, to subject it to the discretion of the states, I think belittle the issue. In my estimation, the states have a mandatory obligation to support the rights of Western Sahara to advance and attain self-determination. Going further, the court's failure to consider the voting patterns of the 8 states as a show of their position in terms of supporting Western Sahara, I think also was problematic, because we didn't need to look so far to identify whether or not the states fulfilled that existing obligation that the court accepts. And this is because other states, including South Africa, where we are having this conversation, supported Western Sahara and voted against Morocco's readmission to the African Union. And these 8 states all voted in support of Morocco's admission. So there was no basis, as far as I'm concerned, to claim that there was no evidence to determine whether or not the obligation was fulfilled. Again, the position that Article 20 does not provide a list of actions for states to take in supporting the right to self-determination, I also think was just an escape route for the court, because no law provides an exhaustive list. Even the understanding of preemptory norms, it's not exhaustive. No law provides an exhaustive list of steps that must be taken by state parties to fulfill any obligation. This is done by the development of the law, either through soft law, through treaties, through all the other machineries of international law. And there was an opportunity in this case for the African court to build on the understanding of what those obligations were. And unfortunately, to my mind, the court did not do enough. Again, let me predicate all of this in saying that, I'm speaking as a litigator, as an advocate, and as someone who wants to push the court to go to the limit, but I'm not speaking in ignorance of what the context of the court is politically and otherwise. And so I know there were a few, there maybe have been a few considerations, and I'd like Zelalem to either confirm or deny. But I think that this was an opportunity for the courts to move things further, to clarify what those obligations could look like. Because in other decisions, especially in the advisory opinion on Namibia, the ICJ gave some instances of what could appear as support. Finally, the argument that the decision to readmit Morocco was that of the African Union Assembly of Heads of State and not that of the state parties, I think also is faulty, because in the context of human rights obligations or human rights broadly, there are duty bearers and there are right holders. The African Union is an entity that has its legal personality, but it's composed of by states that are duty bearers. So the context here of the AU taking the decision and not the states, I think presents an opportunity for us to move things further. I propose that similar to the principle in corporate law, where we lift the veil of incorporation to identify the wrongdoers, I think we need to lift the veil of international mechanisms to identify the wrongdoing of individual organizations or individual member states, in which case the fact that the decision was taken by the African Union should not detract from the fact that the African Union Assembly of Heads of State is composed of by state parties, including the 8 states before this court. And so I think that the court brought us so close, but there's more to be done. And the reason this case is so important is that Western Sahara is the only state in Africa still under colonization. So there may be other opportunities for the court to take things further, and I hope they take it further. As we go into the discussion, the question I like to throw out, because if we maintain the logic of the court, then it could mean that when genocide occurs, state parties can decide what they want to do. But I don't think that's what the court wants to do. So this has to be corrected. And as we all know, as most of us know, Kenya, after the last election, recognized shortly the claim of Morocco to Western Sahara and pulled that back. The question I will have for the court is, if this issue was meant to stand, would it also be seen as something within the discretion of Kenya to recognize or not recognize, because it's clear under international law that you cannot recognize such an issue. So there are things that need to be fixed, but I do agree that this decision moved us forward. I'm just, the party people who was tasked with the job of criticizing this decision. So thank you very much.
Thank you so much, Mr. Ikechukwu, for your very, very passionate presentation on the decision of the court. Now we are in the question and answer segment. So I would like to ask the people on the chat box, and for the HRDA students, class on to ask a question, and also specify the specific panelists you want to direct your questions to. So
Okay, good. Yeah, so thanks to all the panelists for these very interesting presentations. I have a set of 3 questions, and sorry if you think it is a long list. The first question is going to be about the extraterritorial effectiveness of jurisdiction of state under the African Charter. I think Dr. Zephalem presided, it was actually agreed for the first time by the African Court regarding the nature of the right to self-determination. So I would like to know if actually there are other rights that can be considered in the future, and what are the criteria that the court is maybe going to use to implicit recognition of hierarchy between rights. The second thing, I have to repeat. No, I just want to know, how is the court going to define the criteria of application of the extraterritorial jurisdiction regarding other rights, apart from the right to self-determination? I would like to know the criteria, because Dr. Zephalem spoke about the nature of the right. And for me, maybe I didn't read the decision thoroughly, but I would like to know if other criteria apply. The second thing I would like to know is regarding the right to self-determination. Just like Ikechukwu said, it is very blurry when there is no situation of occupation and colonization, if inaction is a breach of that right. So how do we know when a state has some proximity with another state, but is not doing anything to support the right to self-determination? When is it a breach? When inaction is a breach? And the third question is, for me, it is a very interesting issue to also look at through the lens of cessation. Now that the court has kind of recognized a right to self-determination for the Sahrawi Arab Republic, does it mean that some people in a country who have been actually victims of gross human rights violations can argue that the right to self-determination give them also implicitly the right to cessation? And taking examples of previous cases, not before the court, but the African Commission on the South Cameroonians and on the Katanga Republic. So sorry for so many questions, but this is such an interesting case and a good occasion to speak with experts. Thank you.
Is there someone else from the class before we make our switch to the virtual participants? Okay, you can make up your mind in the meantime. Allow. I think we can maybe for now we can just ask Dr. Zephalem to probably answer some of the questions.
Can you hear me?
Yes, we can.
Okay, thank you very much. Thank you for the questions. The first question, which is, I think, directed towards me, is the extraterritorial jurisdiction of the court. As I said, indeed, this is for the first time that the court came up with, it affirmed the extraterritorial nature of its jurisdiction with respect to some rights. The court, in this specific case, focused on the nature of the right to self-determination, because if you compare the charter with the corresponding regional or international human rights conventions, the charter doesn't talk about jurisdiction. Like if you see Article 2, I think, of the ICCPR or the European Court of Convention of Human Rights, it doesn't talk about the scope of the territorial scope of application of the convention. So it's open for interpretation as to the extent of the territorial scope of application of the charter. So the court, since there is that gap in the charter, the court relied on the nature of the right to self-determination, because if you look at Article 20, it talks about peoples under colonialism, people under foreign domination. These words show that the nature of the right, which is being protected in that provision, is or cannot be limited to a specific geographical territory. So if the court has developed any criteria, not yet, which means that it will be something that the court will have to deal with on a case by case. Maybe other rights could also be extraterritorially considered. For example, if you look the right to development, the right to free disposal of natural wealth, so and so on. In the future, the court might find that it has extraterritorial jurisdiction to determine issues relating to these rights. So it is open-ended, and there isn't any specific criterion which has been developed by the court. It's something that we will expect to have in the future. The second one is when an action becomes a breach of international law. Yes, as you know, in international law, a state's international responsibility may be engaged when there are that three requirements: when there is harm, there is a causal link, and there is attribution. So if the inaction or the omission could be imputed through evidence, of course, if it could be attributed, then there could be a breach of international law, including the obligations in the charter. Of course, it's a matter of proof. It's a matter of evidence. And as you know, omission is more difficult to prove than a positive action or commission. So in this particular case, as the last speaker pointed out, some of the respondent states could have, for example, galvanized public opinion and the support of other member states, for example, to object to the admission of Morocco to the African Union. Nevertheless, because of the nature of the right to assistance, the court didn't find their failure, their omission, as violation of the charter. But if the court interpreted, for example, the nature of the right to give us the obligation to give assistance, maybe in a slightly different way, maybe that omission would count as violation of the charter. The last point, the cessation. I think it's important to note that the right to self-determination in international law has dual dimension. The first one is internal self-determination, and the second one is external self-determination. The court did not make such distinction in this judgment, but of course, since the Sahrawi Arab Democratic Republic is recognized as a sovereign state, as a member state of the African Union, the issue is obviously an external self-determination. And if you look at the judgment, the court recalled the findings of the ICJ in its advisory opinion, and it considered as a case of occupation. As you know, in international law, you cannot talk about occupation if it is controlling the internal border of a state. And occupation presupposes that it is there must be a foreign power occupying the territory for a sovereign nation. So in this specific case, the issue was external self-determination, and even the court talked about colonization. The Sahrawi, the people of Western Sahrawi, as people who are still, whose colonization process hasn't yet completed. Decolonization process hasn't yet completed. It was just recalling what the ICJ said. But apart from that, self-determination could also have an internal dimension in the charter. So it doesn't mean that it gives you an automatic right to secession. So we should see it in that light. Thank you.
Okay, thank you very much, Dr. Zelalem. I think Ikechukwu will answer some of the questions that have been directed to him. But unfortunately, in the interest of time, when Ikechukwu is done with his questions, I would just want, I see there are some hands, but apologies, we just have to quickly wrap this up. So I would want Mr. Sidai and Praise God to just in 1-2 minutes, just give us some of their concluding thoughts when Ikechukwu is done with his questions. So we would have Praise God and we'll have Mr. Sidali in that order.
All right. I'd keep it really short, but just to clarify again on the extraterritorialism issue, my understanding of the court's analysis on that issue was in relation to the right in question and the impact of the resultant obligation arising from the right to self-determination. In particular, that was a response to the objection of the state parties, saying that the violations complained about arose outside their territories. And because they arose outside their territories, they couldn't be held responsible. The court's response was that with reference to human rights law, particularly, but even more specifically with reference to norms, preemptory norms of international law, that those erga omnes obligations that arise operate extraterritorially. And because they do operate extraterritorially, the court has the jurisdiction to entertain the allegations of the violations of those rights. So just in addition to what Zelalem had said. On the issue of secession, is also in addition to what Zelalem has said, the understanding of the right to self-determination, especially in that external component, refers to the process that leads to decolonization and ends there. What continues after that is the internal component of self-determination, which refers to participation, ensuring representation of minority groups and the like, ensuring participation in government, ensuring consultation, free and informed, consent consultation and the like. All of that also embodies what self-determination really is. So in the context of countries like Cameroon that has been decolonized, the question of the external domination does not arise. So since that does not arise, there would be no question of like the right to self-determination, and this case would not be basis for a legal claim to the right to secession. But we can have this conversation for a whole day. And then on the issue of your question around inaction and how that gives rise to a violation. Again, my understanding is that the right to self-determination has been long unpacked through general comments, through advisory opinions, through resolutions, and there are a lot of examples that we can follow. But there are also positive examples that we are living through in terms of how other countries have supported the right to self-determination of Western Sahara. So I think one thing that the court did here was to collect and put together what is in existence in terms of the understanding of the right to self-determination. But what I think the court could have done was to now give a sense of what could appear as actions to be taken. And it even said that, states could have galvanized support. So, when we turn that around, you could say that galvanizing support could be a way of supporting, the right to self-determination. But, going back and forth, it may be difficult to understand what inaction could be. But, I would say that that's the work that lies ahead of us to understand. And then finally, on Kenya's issue, on the question on Kenya, the president got sworn in, and I don't know if it was excitement, but he released the tweet. And then there was now a statement that came out afterwards. The statement that came out afterwards is more in line with international law and where things stand, abiding by the UN resolution and the like. The tweet that went out was not. And that is why it was pulled back. So I don't know if that clarifies things, but that also shows you that the issue of self-determination with Western Sahara in particular is sensitive. And I think that I would have loved the court to go a bit further in its analysis of the issue.
Thank you very much. And I think, like I said, we'll just have Ms. Praise God for 1-2 minutes, just your concluding thoughts, and Mr. Sidali for your concluding thoughts as well.
Thank you, Fausto. For me, I will stress on the last paragraph of the judgment on how the court not only limited the obligation upon the states parties to the case, but it went further to put an obligation to all member states of the African Union. So for me, it's to call upon how, as a continent, how can we reach out to our particular states and push towards ensuring that this particular paragraph of the judgment, specifically paragraph 323, is implemented to ensure that our states take initiative for the self-determination of the people of the Western Sahara, but also to ensure that our states do not take any action that will create a lawful recognition of the situation in Western Sahara and Morocco. So it's basically calling upon us to take initiative to ensure that this particular part of the judgment is clearly implemented by the African Union states. Thank you.
Thank you very much. And we'll just have Mr. Sidali just for your concluding thoughts in 1 minute. Apologies.
Thank you very much. And thank you for these previous very important presentations. I think the finding of the courts on the duty of the non-recognition and the non-assistance, it's confirmed with the opinion of the Advocate General of the European Court of Justice that already concluded in 2018 that Morocco occupies illegally Western Sahara is in violation of several premonitory norms of international law. And this is definitely, it's linked to what's been said, that the concept of the external interpretation of the implementation of the self-determination linked with the decolonization issue in Western Sahara. And this is the real interpretation, and the court was right on that regard. Also, I think that the ruling of the court and to confirm the the nullification of the EU Morocco agreements by the General Court of the EU. So I think also this is a very encouragement judgment. That's also the African states and the African Union will take for further steps to ensure the implementation of the Sahrawi rights to self-determination and independence, and ending the last the colonization process in Africa. Thank you very much.
Thank you very much, Mr. Sidali, for that. Now I would call on the Director of Center for Human Rights to give us concluding remarks and his thoughts on this.
Yes, thank you very much, Felusha. I'm sure that I must first just thank everyone for their patience. We've not only started late, but even if we started in time, we would have run late. So we've tested your patience on many scores, but thank you very much for being part of this discussion. We really appreciate you. I mean, I cannot be brutal and now try to summarize in one way or another the proceedings in a number of minutes, right? Let me say, first of all, just in terms of the name of the case, I wish the case was not named after an individual complainant, but named after the peoples of the Western Sahara, the Sahrawi people. I think it is possible. It's also, clearly it's an individual application, but I think that element could have been captured more and better in the name. In terms of the significance of the case, clearly we are convinced this is the first time that the Sahrawi Arab Democratic Republic appears before an international tribunal. That in itself is very significant. It's the first time that the African court decides a case related to the right to self-determination. This case will stand for a long time as very significant. On jurisdiction, we heard extraterritoriality, really a significant landmark. And I think the tension between politics and law in the kind of arguments by the respondents and how the court dealt with it, very interesting on jurisdiction. On admissibility, I think it is very much the issue of taking a case against 8 states and how the admissibility requirement works, whether you have to take it to each of the 8 states or, you know, how the court deals with that is very significant and important for such subsequent cases. On the merits, I think it's really about the framing of the case, isn't it? Like Ikuchuku was also saying, I think its case was brought on a number of grounds. The court decides to really crystallize it around Article 20, sub-Article 3. If I go in conclusion on this discussion to that famous paragraph 323, the so-called obiter dictum, right? So in a sense, this is a case lost on the merits, but celebrated as a win because of this obiter dictum. But I ask myself, does the obiter dictum now say something that is more political? If it talks of the nevertheless that the states have the responsibility, is it a political responsibility? Because if they have that responsibility, and it's a legal responsibility, and that responsibility is, I quote, not to do anything that would give recognition to the occupation as unlawful or impede the enjoyment of the right to self-determination. If the case were framed around that question, did the states, these 7, 8 states, did they do anything that gave recognition to the unlawful occupation as part of the right to self-determination, how it is framed in the obiter, to turn the obiter kind of upon itself and ask, is the obiter really telling us that if the case were framed along the lines in the obiter, it would have been finding a violation? Or is it telling us that this is politics and not law? It's really for me either of the two. And then what does it say to us how the case could have been framed? Concluding by saying thank you very much again for everyone's participation. I think we were also very privileged that the Deputy Chairperson of the African Commission on Human People's Rights, who is here in Pretoria for dialogue tomorrow, Madam Maya Fadal, joined us for this. Thank you very much for your presence, for everyone's presence. Thank you for our presenters. I'm not going to repeat everyone's name. You know you are valued and appreciated. Thank you for the class who are present here for your lunchtime incursion. And then to our moderator and to our unit, the Implementation and Litigation Implementation Unit of the center that had been putting this together, and the assistance they got from others in the center. Thank you to all of you. And we look forward to seeing you all when we discuss one of the quasi-judicial bodies' findings in a few months' time. Thank you very much for tuning in, and have a great day. Thank you so much, everyone.
So